So it's not always doom and gloom here at the Katie Phang News Channel. I always bring you good news. I always bring you solutions. Today we'll stick with the good news. You might have missed this past Friday. A federal judge in the Middle District of Florida, Tampa Division, said to Donald Trump, "Get the hell out of my courtroom with your bullshit lawsuit." Just a refreshing of your recollection. Back on September 16th, just last week, Tuesday, Donald Trump sued the New York Times for $15 billion in this absurd defamation lawsuit. And I covered this last week quickly because honestly, as I represented to you last week, and I'm feeling a little validated because the federal judge agreed with me, the lawsuit's dumb. Not only is the lawsuit dumb, but its allegations are just absurd. And it was an 85-page complaint that was filed against the New York Times, Suzanne Craig, Peter Baker, and others, because Donald Trump didn't like the way that they wrote about him. That's it. It's not grounded in any facts or reality. And so when I saw the lawsuit, I'm like, this is a joke of a lawsuit. Well, lo and behold, federal judge Stephen Merriman, who is a senior district, Stephen Merriday, sorry about that, senior district court judge, a 1992 former President George Herbert Walker Bush appointee, he agreed with me. And he said this lawsuit, bye-bye. Now, as it was, and this is not any special favors being given to convicted felon Donald Trump, Trump is now being given 28 days from September 19th to be able to amend his lawsuit to fix the problems. But now he also has a page limit. The judge says your amended complaint must not exceed 40 pages. And there's a reason why, and we're going to get into it. So let's get into it. So let's start procedurally what's happening. So Trump files this lawsuit on September 16th, and on September 19th, just a mere 3 days later, Judge Merriday enters this order, sua sponte. Sua sponte is a Latin phrase that's used in the legal world to signify that on its own, it's kind of this suddenly on its own, the court has done something, meaning the New York Times didn't file a motion to dismiss. None of the individual defendants moved to dismiss. In fact, no activity had been done by the defendants in this case yet. The judge, Merriday, said, this lawsuit's so bad, I'm kicking it out of my courtroom. I'm giving you the chance to fix it, Donald Trump, but it's so bad, I'm not even going to let activity happen on this version of the complaint. So, sua sponte, yet another legal phrase y'all have learned. Sua sponte, the judge has said, done, get it away, not going to be in my courtroom anymore. And the judge enters a 4-page order that is filed on Friday. And the order is a delicious piece of art. It is so worth walking through with y'all because it just underscores and highlights how absolutely absurd these lawsuits are that are brought by Donald Trump. And you would hope, unlike we've seen the bending of the knee and the capitulation by CBS, Paramount, ABC, etc., you would hope that you would see the New York Times continue to defend itself against this lawsuit, and I think it will, as the press statements have suggested. But anyway, the judge says, and he makes a run at dinging the lawyers for Donald Trump. At the very beginning of the order, he says, as every member of the bar of every federal court knows, or is presumed to know, Rule 8A of the Federal Rules of Civil Procedure requires that a complaint include a short and plain statement of the claim showing that the pleader is entitled to relief, end quote. And that is the Federal Rule of Civil Procedure, a lawsuit, a complaint. It is the initial document that gets the lawsuit started. And if you're being sued in a civil complaint, you want to understand as a defendant what are the charges or the claims that are being brought against you? Makes sense, right? So I know as a defendant how to defend myself because I'm aware of the facts that are being alleged that are specific to me if there are multiple defendants, and that the causes of action that are specific to me if there are multiple defendants, so that I know how to frame my defense to respond to your lawsuit. And it's funny because even in that first paragraph, Judge Merriday says to Trump, the urgency or importance, parentheses, real or imagined, and parentheses, of the dispute is governed by Rule 8, as every pleading is in federal court. I mean, it is true, right? Trump has manufactured emergencies, as we know. Moving on to page 2. Alleging only 2 simple counts of defamation, the complaint consumes 85 pages. Now, I want you to read this order yourself. It's only 4 pages. It's well written. The action verbs alone are so entertaining and worth enjoying. That is the reason why I'm highlighting them for you. The complaint consumes 85 pages. Count 1 appears on page 80. Count 2 appears on page 83. Pages 1 through 79 plus part of page 80 present allegations common to both counts and to all defendants. Each count alleges a claim against each defendant, and apparently each claim seeks the same remedy against each defendant. So the judge, again, says, hey, 2 simple counts of defamation. It takes 80 pages for us to get to the first claim, and then 83 pages to get to count 2 of a total page count of 85. It's crazy. Even under the most generous and lenient application of Rule 8, the complaint is decidedly improper and impermissible. The reader of the complaint must labor through allegations. The reader must endure an allegation. Similarly, in one of many, often repetitive and laudatory toward President Trump, in parentheses, but superfluous allegations, I mean, wow. Judge Merriday suffers no fools, spares no rod, when he wants to let Donald Trump's lawyers know what he thinks about the allegations as framed and as phrased in this lawsuit. On page 3 of this order, Judge Merriday says the following. The complaint continues with allegations in defense of President Trump's father, acquisition of the wealth, goes on, and with much more persistently alleged in abundant, florid, and enervating detail. Enervating meaning it draining. So the lawsuit has abundant, florid, and draining of energy detail. The next paragraph. A complaint remains an improper and impermissible place for the tedious and burdensome aggregation of prospective evidence, for the rehearsal of tendentious arguments, or for the protracted recitation and explanation of legal authority putatively supporting the pleader's claim for relief. As every lawyer knows, or is presumed to know, a complaint is not a public forum for vituperation, an invective, not a protective platform to rage against an adversary. Vituperation means bitter, like your bitterness or your bitter language. A complaint is not a megaphone for public relations or a podium for a passionate oration at a political rally or the functional equivalent of the Hyde Park Speaker's Corner. So I have a confession to make. I did not know what Judge Merriday meant by the Hyde Park Speaker's Corner. So I went and I looked it up for myself, and I'm going to share it with y'all because I thought it was really worth sharing. So the Hyde Park Speaker's Corner is located in London, England. It's located on the northeast edge of Hyde Park, nearest the Marble Arch and Oxford Street. Historic figures such as Karl Marx, Vladimir Lenin, and George Orwell were known to often use the area to demonstrate free speech. In 1872, an act of parliament set aside this part of Hyde Park for public speaking. Even today, on a Sunday morning, it's not unusual to find crowds gathering at Speaker's Corner to listen to enthusiasts expounding their views. Anyone can turn up unannounced to speak on any subject, as long as the police consider their speeches lawful. I thought this was pretty cool because what Judge Merriday is saying, obviously, is you cannot use your lawsuit complaint in federal court as the functional equivalent of that public speaking area at Hyde Park, that corner. Judge Merriday goes on, a complaint is a mechanism to fairly, precisely, directly, soberly, and economically inform the defendants in a professionally constrained manner consistent with the dignity of the adversarial process in an Article 3 Court of the United States of the nature and content of the claims. This complaint in this action extends far beyond the outer bound of that latitude. This complaint stands unmistakably and inexcusably athwart the requirements of Rule 8. This action will begin, will continue, and will end in accord with the rules of procedure and in a professional and dignified manner. The complaint is struck with leave to amend within 28 days. The amended complaint must not exceed 40 pages, excluding only the caption, the signature, and any attachment. Signed, September 19th, 2025, Judge Stephen D. Merriday, United States District Judge. I would be humiliated and embarrassed if I were the lawyer for Donald Trump, who got this order entered, sua sponte, the judge on his own entering this order, dismissing the complaint and giving Donald Trump 28 days to amend it. I'll talk about one of the lawyers that filed this lawsuit. His name is Alejandro Brito. He's a lawyer based in Miami, Florida. I sued him for professional malpractice, and the case settled. There are lawyers that are willing to take up the laboring oar to run the risk of their Florida bar licenses and other bar admissions into places like the Middle District of Florida. They're willing to do it for what? For the high holy dollar? For the allure and the prestige of representing somebody like Donald Trump? We've seen what happens to lawyers that represent Donald Trump. They go through two clear paths, right? The fork in the road for them is very telling. Some of them end up disbarred, criminally indicted, a la Rudy Giuliani, Sidney Powell, Jeffrey Clark. I could go on, right? And then some of them go the other fork in the road. They go the other path. Some of them, like Todd Blanche, Emil Bove, Pamela Jo Bondi, Alina Habba, they get rewarded. Maybe it's just the toss of the coin, right? To see where they end up. But all of them end up with literal mud on their faces and stains on their reputations. And lawyers, even in the civil cases that are bringing these lawsuits, that are just humiliating to read. The fact that any lawyer would want to put their signature and their bar license on a lawsuit that a federal judge who's been sitting on the bench since 1992 and was the chief judge for many years in the Middle District of Florida, the fact that they'd be willing to put their names on lawsuits just to satisfy the whims and fancies of a client like Donald Trump, I would not want to have that person be my lawyer. We've seen judges actually enter sanctions against Donald Trump's lawyers like Alina Habba and Donald Trump for frivolous filings under Rule 11 of the Federal Rules of Civil Procedure. That's a very real possibility here, assuming arguendo, the defects can be cured, which they probably will. All the lawyers have to do is get rid of 80 pages, more or less, of their lawsuit here. We'll watch it carefully, folks, as we do here at this news channel, but I'll tell you, there has to be something said about what I call the enablers, the lawyers that enable Donald Trump to continue with this type of vexatious litigant conduct. And there should be accountability for those lawyers. Bar associations, bars, they should be holding these people to account that pass the bar exam, promising to also uphold and do their oaths as lawyers. They're not honoring those oaths either, are they? I'll see you on the other side. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.